Welcome back to more questions in the comments. I promised daily updates here, although it's been a long day, I promised, and I shall deliver. So the wizard asks the question, does customer or client differ from consumer? Since consumer law relates to personal consumption, can it be argued that the 2015 Act, the Consumer Rights Act 2015, does not apply to customers or clients? Now, the term customer or client does not necessarily denote a consumer. A consumer is defined in the Act as a person that is acting wholly or mainly outside of their business, trade, craft, or profession. In other words, they are acting in an individual capacity for themselves for their own personal consumption, as the wizard's question suggests. So if that person is acting in any way in the capacity of a business, trade, craft, or profession, then they are not a consumer for the purposes of the Act. So it matters not whether you refer to them as a client or a customer. That could actually denote either a business customer or a consumer customer. A customer just means someone that is coming to your business and buying from you. And so it doesn't really denote by itself and not without more whether they are a consumer or not. How they are acting and the capacity in which they are acting will denote whether or not they are a consumer. And remember, if the trader says or alleges that the customer was not acting in the capacity of a consumer, then the trader must prove it. In other words, the trader must prove that the customer in this case was acting in the capacity of a business and not a consumer. The reason that is important is obviously because if the person was acting in the capacity of a consumer, then they benefit from the rights in the Consumer Rights Act, vis-a-vis the right to reject, the right to repair, the right to replacement, and so on, which I deal with in my other videos. Thomas Reeds, again on consumers, asks the question, is there a reasonable time frame for a business to inspect and repair an item? I'm currently dealing with, he says, the motor ombudsman on a second-hand car and disagree with the adjudicator's decision. Now, this is a compound question because if you've agreed to an adjudicator, it will depend on the agreement as to whether you've agreed to be bound by their final decision. So that is a separate issue that I'm not going to deal with. The question I will deal with is whether or not there is a reasonable time frame for the business to respond to inspect and or repair an item. Now, this under the Act is not to be with any unreasonable inconvenience to the consumer. So reasonably speaking, a week or two is probably okay. A month or two is probably not okay, even if it's a car that's being inspected. A week or two or even a few weeks should be a reasonable time period, but not an unreasonable inconvenience to the consumer. That is set out in the Act, but as for specific sections, that's for Black Belt Barrister, so you can check out my videos there. I do go into very specifics as to which section of the Act covers this. Goatee Goat says, firstly, love the channel. Thank you very much. I'm glad that you love the channel. And quick question on Chili Con Carne's channel is mentioned. It's been said that a TV license, quote, sales enforcement officer are going to start using body cams. How does that stand with them filming inspections? And are we within our right to stop them? So you haven't mentioned there anything to do with a warrant and things like that, but let's take it as a standard visit. If they are using body cams and it's an organization, they are going to be subject to data protection, which includes GDPR, which means you can submit a data subject access request and get copies of any footage that incorporates you and your property within that video, because it's an organization. They will be subject to those rules and they need to disclose that to you. Equally, there is nothing to stop you from filming them if they come to visit your property. As to whether they can use it when enforcing a warrant, that is an entirely separate matter, but would still be subject to data protection in the most general sense. George Woods asks about things like pepper spray, so presumably about self-defense. In fact, he goes on to say, that is clearly used for self-defense and is very handy for women. Does it count as a weapon? Well, a pepper spray by that definition or by that name suggests that it uses some kind of chemical. So anything that disperses any kind of chemical by means of a liquid or a gas is going to be considered a firearm. Section 5 of the Firearms Act 1968, these are known as Section 5 firearms, states that any weapon of whatever description designed or adapted for the discharge of any noxious liquid, gas, or other thing. So I suggest that any kind of weapon, be it self-defense weapon, spray, or any kind of thing like that, if it is dispensing a liquid or a gas, which is any kind of chemical or noxious thing, as the Act suggests, which is very broad, will be a form of firearm under Section 5. So it will be a Section 5 firearm. So yes, it is a weapon, and I would not recommend that you carry or use any such thing. Another question, although I'm going to omit the name, says, how would I go about filing a non-molestation order without a solicitor? The person in question has a previous conviction and abuse is ongoing. So in this scenario, I would always recommend that you seek formal legal advice, but if you wanted to do it by yourself, you can fill out the forms, but my suggestion to you would be to check it over thoroughly and to take it into a court and do it in person. That way the court is more likely to take it seriously. They are more likely to take it as a serious and imminent threat upon you, and thus the application is more likely to be successful. But I repeat, I would always urge that you seek legal representation for doing so. Steve Knight asks the question, can you explain the difference between an offside overtake, that's overtaking on the right hand side another vehicle, and an offside pass? Well, the only distinction there is if for the pass, if there are two lines of moving traffic and one line is moving very slightly quicker than the other, it's not strictly an overtaking maneuver. An overtaking maneuver is typically if you are deliberately moving out to overtake someone or another vehicle that is moving slower than you and slower than the speed limit. Therefore, it is legal to overtake because you need to move out and overtake that vehicle. An offside pass means you are passing the vehicle on the offside, the right-hand side of the vehicle in front of you. But a pass would suggest that you are just passing by. So it's not really a term that I would use frequently. It's just passing another vehicle. Richard Walker asks, if undertaking was banned, what would happen to the bodies? Hudayfa asks, what happens if I claim less than £700? Would it go to a court hearing? Well, yes, potentially. Any court claim amount, even up to £300. The court filing fee is £35, according to the gov.uk website at present. So even for a claim up to £300, you could file this in court if someone owes you that amount of money, or you claim they owe you that amount of money. And ultimately, it would go to a court hearing if it was defended, disputed, and ultimately you had to go to argue the case that they owed you the money. So yes, the amount doesn't matter. 300 or 300,000 or £3 million, it doesn't matter. They could go to a court hearing. E Wild Goose asks the question, if that is your real name, can I ask for you to explain further on merging with regard to Rule 134 of the Highway Code, of course, which seems to suggest merging is only for when vehicles are moving at very slow speed. So yes, I can. Rule 134 says, and I quote, you should follow the signs and road markings and get into lane as directed. So obviously if there's a sign, you follow it, you get into lane as you're told to do so. In congested road conditions, do not change lanes unnecessarily. In other words, if there's lots of traffic around, don't keep changing lanes, stay where you are. Merging in turn is recommended, but only if it is safe and appropriate when vehicles are traveling at very low speed. So when vehicles are there and you are moving at a low speed, you merge in turn, i.e. zip merge one after the other. It then says, for example, when approaching roadworks or a road traffic incident. It is not recommended at high speed. So if you do have lanes that are merging, either because of roadworks or because of a traffic incident, or because the lanes simply merge together, which is a more recent thing, clearly it is not recommended if vehicles are traveling at high speed, because that would mean that vehicles are zipping in front of each other at high speed into the same lane, which of course is not recommended. Michael Smith follows on with this idea and says both lanes should be used to the full capacity, quoting me. Where in the highway code or where else does it say this? Well, frankly, Michael, based on the guidance in the highway code, using both lanes to merge in turn is common sense. Obviously, this doesn't really apply merging in turn at high speed, which is what the highway code says to avoid. But if there is heavy traffic on the motorway, it does say to merge in turn, which suggests you use both lanes. So this is my interpretation of the language of the highway code, and it makes common sense. So those were the few questions I picked out just now. I will be picking out more tomorrow. So if you want your question answered, make sure it jumps up. Usually if you're a channel member or if you make your question stand out in one way or another, I'm more likely to see it. But in the meantime, thank you for watching this extra segment of questions in the comments on Black Belt Secrets for and on behalf of Black Belt Barrister. Make sure you're subscribed to both, and remember, stay humble and subscribe.